Hi, my name's Chris Dickey. I'm a band director at South Preston School in Preston County. I've been a music teacher for 10 years and I have enjoyed it, but I'm looking forward into getting into administration. My hope is to get into private Christian education as a school leader, a principal, or a superintendent of a large Christian school, and possibly in my career as higher up administration in a Christian college somewhere, maybe even possibly as the president. But I think I would be happy as just even just retiring as a dean of a music program somewhere in a Christian college. I'm really looking forward to getting involved in something like that. After this, I may pursue a doctorate or an educational specialist in higher education administration as well. I believe this class has prepared me well for some of the law topics that I'm definitely going to address regularly. The first one I want to address is the First Amendment relating to Tinker versus Des Moines, which was a landmark Supreme Court ruling that dealt with the right of public school students to express free speech and opinions in a non-disruptive manner in the schools. The petitioners sought injunction of the school district policies relating to the ban of armbands and nominal damages incurred. So in 1965, there was a group of students, including Mary Beth Tinker, who was a junior high school student at the time, and her brother and a few other friends decided to wear black armbands to school in silent protest of the Vietnam War. Prior to this occurring, the administrators of the Des Moines Independent School District met to formulate a plan when they kind of heard this swirling around that this could happen, banning armbands completely, and that for the entire district, and that any student caught wearing armbands would be removed from their class and suspended until they decided to return without the armbands. This case was first filed in the U.S. District Court for Southern District of Iowa. The court dismissed this case before hearing either side. It then went on appeal and referred to the Circuit Court, which issued a 4-4 split decision. And these actions led to the U.S. Supreme Court granting certiorari. And the Supreme Court voted 7-2 in favor of Tinker, ruling that the actions of the Des Moines Independent School District were indeed a violation of the First Amendment rights of the students, and that students do not shed their right to free speech and expression when entering the school. The big piece for this case was that the courts determined that as long as there was not a disruptive piece, that students were allowed to continue their free speech. So as long as students were still on task in the classroom, there was no destruction of personal, private, or public property, and that there weren't fights going on, then there was not a major disruption going on with the school day. This has really impacted a lot of years of education because it's granted students the right to free speech. And we see this all the time. Schools continue and students continue to get more political as they go. I remember when I was a young kid, I don't ever really remember being political or any of my friends being political, but it's really taken over and kids are speaking out, they're walking out, they're doing various things, and it's all because of this case. So as administrators, it's important that we do recognize the rights of students' free speech, and we don't let our biases get in the way of things that we may not agree with. We have to weigh, okay, is this really creating a disruption, or am I just offended with it personally? So that's what we really have to remember as administrators. The second case I want to look at is the Vernonia School District versus Acton. And this deals with search and seizure. And this is a student who filed a lawsuit against the Vernonia School District because of their policy of drug testing. So the Actons filed a lawsuit seeking declaratory and injunctive relief from enforcement of the policy on their son on the grounds that the district policy violates the individual students' 4th and 14th Amendment rights of the U.S. Constitution. So with this case, the whole point is there was the Vernonia School District found that there were major drug issues, and they were really high in student athletes. And oftentimes student athletes were becoming the leaders of the drug related incidents that were going on. And there were a lot of physical harm incidents that were happening with students related to drugs that were involved in athletics. So as a result, the school district came up with a policy that all athletes were to submit a required form that at any time, 10% of the athletes would be randomly selected to participate in drug screening, which would be observed by a licensed professional. The Actons filed lawsuit against the district after their son was denied participation due to not signing the required forms. And they said that this new policy violated the 4th and 14th Amendment right of their son, James Acton. The case went before a bench trial, and the court ordered denial of claims due to merits and dismissed the actions. The case then went before the United States Court of Appeals 9th Circuit and was reversed, citing the policy did violate the 4th and 14th Amendment rights of the student in Article 1, Paragraph 9 of the Oregon Constitution. Following this, the United Supreme Court granted certiorari and took up the case. The Supreme Court ruled that the former ruling of the United States Court of Appeals judgment was in error, and therefore vacated their judgment in favor of the Vernonia School District. And the big issue was that students voluntarily participated in sports. Therefore, they hold a lesser view of privacy due to the athletic requirements. The court made this ruling due to the fact that students are not individually singled out, but all participants are required to do the testing. Therefore, the court considers the district policy reasonable in considering 4th and 14th Amendments requirement for search and seizure. And the schools have a unique piece to search and seizure because we can't easily get warrants because those are carried out by law enforcement officers, so we can't get warrants. So the court determined that reasonableness was the piece that was required in any situation involving schools and students and administrators in search and seizure of personal property, as we can't obtain warrants by law. It is important as administrators that we remember that student privacy is important, and we cannot break students' trust. But we also have to act in the best of that student, in the best of the students as the whole. But we still have to be careful not to break their trust because they do have rights. But it's very important that we have a reasonableness when we search students, when we suspect something. For example, I wouldn't just jump on what one student said about another student because they could be lying. But if a teacher were to recommend or another staff member say, hey, I saw this student doing this, I'm going to look further into the case and be more likely to say, okay, there's reasonableness here. If it was just a student saying, hey, I saw so-and-so with a vape or whatever it is, then I'm going to look into the case a little more strongly before I just go and search and take students' personal belongings. The next case I want to look at is Doe versus Withers, a case from where I reside in Taylor County. I actually know some of these people personally, have worked with some of these people involved in this case, but it has to do with the rights of public education students and families, or special education students and families. So the petitioners filed for injunction for immediate compliance to the order of the student's IEP and sought a total financial restitution of $60,000. They took to court the high school principal, the history teacher, and the superintendent, and the Board of Education. And what happened is there was a social studies teacher named Mike Withers, and he refused to go along with the student's IEP. And this caused his grades to continue to drop and drop and drop. There was a time when Mr. Withers was out of the classroom, and he had a sub for several weeks. So the parents noticed that as the sub was following along in the IEP, his grades went up. The student's grades started to go up. And so they complained, and they filed a lawsuit because Mr. Withers was not following the student's IEP and was violating the terms of the IEP. So the plaintiff was awarded in judgment a sum of $15,000 from the defendant, Michael Withers, while the principal, the superintendent, and the Board of Education were absolved from wrongdoing and damages. The big part to this case is that the principal needed to be more involved, and the superintendent needed to be more involved in making sure the teacher was complying with the required IEP. And I've said before that the principal is a bridge between the special educator and the classroom teacher. And so that really has to happen. You have to be a bridge, and you have to make sure that the students' needs for a free and appropriate public education are communicated, and the importance of that is communicated to all of the staff regularly. And that's the duty of an administrator as an instructional leader, is to be that bridge. The next case I want to look at is against teacher and student relationships, and it's an inappropriate relationship between a teacher and pupil. And this happened in Raleigh County Schools, where Michael Cooper in 1996 was hired as a full-time teacher at Woodrow Wilson High School and as a teacher and coach at Independence High School. Mr. Cooper began receiving some love notes from a student, and he chose to respond in what was not really a sexual manner, but yet was immoral. She started writing him notes. He began responding. Then it became more serious. They began to text. They began to have digital conversations, to which he lied and said he did not. So this went before a grievance board. They did terminate the Raleigh County Board of Education terminated his employment for unethical conduct and immoral conduct. And the Raleigh County Board of Education was able to provide proof that Mr. Cooper's actions, while not sexual in nature, were immoral, which violated specific policies relating to employee conduct. They also found that Mr. Cooper's actions of defiance of administrative orders to cease contact with the student were insubordinate and a willful neglect of duty. Therefore, his dismissal was warranted, and so the grievance board found in favor of the Raleigh County Board of Education. It's essential for administrators to be very involved in what's going on with their employees. You have to set clear expectations with staff. You have to remind them gently but regularly, and set an example of professionalism in our own careers. Excuse me. We can't just, as administrators, just go along and imagine that everything's going perfectly all the time. We do have to remind our staff of personal boundaries. And this case really leads me to think that professionalism starts from the top down. So what the boss exhibits in their own career will be exhibited throughout the building with both staff and students. So I believe that's a big piece for administrators in this case, is that we have to be exhibiting what we expect from our teachers. And if not, if they're not displaying what we expect, then we've got to be willing to take action against it, to take a stand for what's best for the student. The next case I want to address is Joshua DeShaney versus the Winnebago County Department of Social Services. And in 1984, Joshua was a 4-year-old boy that lived with his father. After some divorces and different things that were going on in the family, the situation got bad, and Joshua began to be regularly abused by his father, Randy DeShaney. And eventually he was found with traumatic brain injury, which led him to be institutionalized for the remaining time of his life, because of he was beaten so badly. The mother decided to sue the Winnebago County Department of Social Services for alleging that they had deprived their child of liberty of bodily integrity and violated the child's right to due process under the 14th Amendment by failing to remove the child from his father, Randy DeShaney. Mr. DeShaney was arrested and found guilty of child abuse and sentenced 2 to 4 years in prison. The United States Supreme Court ruled in favor of the Winnebago County Department of Social Services on a 6-3 decision in this case, and the court ruled that due process clause does not indicate a duty of the state to provide protection against private violence if the state did not create the harm. For administrators, this case really causes us to take a sighing breath, because as mandatory reporters, we're not going to catch everything, every little piece of abuse that happens. We try our best, but we're not going to catch everything. And if there was a responsibility on us that we could be held liable specifically against private violence, that could be very detrimental to our jobs and to the schools and their boards of education. So the clause that the court's decision, it says the clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimal levels of safety and security. While it forbids the state itself to deprive individuals of life, liberty, and property without due process of law, its language cannot fairly be read to impose affirmative obligation on the state to ensure that those interests do not come to harm through other means. So the administrators, the teachers, we stand as people that have to take up for our students and their bodily welfare, physical welfare, spiritual welfare, all of those things. But this court ruled that we can't be held responsible for private violence that we don't know the extent of. We are required to definitely act on what we see, but we're not going to catch everything. And quickly summarizing, a quote to consider that I found interesting throughout the text was that in the ethical leadership and decision making in education, in some instances, the special characteristics of schools have been used to place safety ahead of individual rights. In this respect, some scholars have questioned the erosion of rights, and that was written by Stefkovich and Shapiro on page 260. And in summation, I feel that our current situation in the school systems speaks specifically to this quote. We see administrators and teachers having to make tough, highly stressful decisions because of the decisions of politicians and county board members. We see specifically a time when community concern outweighs the individual rights of people and students, all for the sake of what we consider the greater good. In my opinion, I believe there is a great eroding away of personal rights in the public forum. This creates a very difficult scenario as administrators, especially central office administrators, that must face down the views and opinions of elected board members and politicians that often turn their backs on the very citizens that elected them. Administrators find themselves bearing the brunt of the parent concern rather than the elected officials, because even though we aren't making all the decisions, we're the ones obligated to enforce them. And it's never been a more crucial time for administrators to know what they believe concerning the education of the child. Because what is best for the education of children could one day be easily swept away by a minority. As society goes, so does the government. Therefore, I believe school law will be a revolving door of change in the coming years. I don't want to have a grim opinion or view on administration or even the schools in any way, but no longer are educators looked at as professionals. We're often looked at as the enemy for having to enforce the rules and policies that others with little understanding have made. The law is quickly losing balance by the hands of the few at the expense of many. I thank you for the opportunity, Dr. Haig, to learn in this class. I thank you for your excellence in preparation of this class. And I apologize that this video went over, but I was having a hard time getting all of that information in this video. I hope I was able to communicate everything the way you expected. All right, thanks again, and I look forward to another class with you.